must be physically present to come and address this issue before Nigerians on his honor. On his honor. It's only when all these things are utilized and then we now go to other sections of section 80 to 89, issue warrant of arrest. We exercise patience because we are representing all of you. But on his honor. And the fact that this committee is the one even supervising him, supervising that agency, he must also give this committee a honor. You cannot ask us not to do our work. We are democratically elected here. So bringing court summon is an afterthought. It will not be accepted by this particular committee. It will not.
This is a good committee. I don't know if I can...
Did I ask you to speak? I didn't ask you to talk.
I'm asking for permission to speak, sir.
No. I don't give no permission to speak for now. You said you came with 2 summon. Submit the summon. It's void ab initio because there was this particular this case was not in court. Ab initio. If it were to be in court, the second day we would dismiss it and say they should go to court. And then if this one is fabricated, we know who is the owner. We will ask MTN to give us the owner of this particular phone that answered that case. We will go and bring him out.
In view of what is transpiring, we have an application before this honorable committee. And our application is simply to invoke the ground norms, the law that unites this country, the law that regulates every bit of our engagement in this country, which is the Constitution, the 1999 Constitution as amended. We're citing section 89, sub 1, paragraph D, urging this committee to invoke its constitutional powers to issue a warrant of arrest to ensure, because before this committee, no evidence from the beginning of any medical illness tendered before this court, this committee, by the respondent. All this while, we have been spending our money, traveling from far distance to this place, taking care of ourselves, taking care of the petitioner and his family. He's no longer working. The burden of taking care of him and his family has been on us. And this, the respondent has refused to come to court, only to be telling to the committee, only to be telling this committee that he's ill. Today, this, my colleague, is the 3rd person representing him. Different people on each day we come. Different person representing him. Today, another person. Yes, this is our position. That, then secondly, to set aside the purported letter and the content thereof. It is not known to us, neither this committee. Who submitted this letter? Who brought this letter? Before the Senate. The person is a spirit. We don't know the person. And that is what makes this letter incompetent. The letter found itself into the Senate. We urge you to discountenance this letter.
Thank you. And we must know whether it is an arrangement by the Code of Conduct Tribunal chairman to ask somebody to write this letter to the committee to withdraw it and put this phone number there. So we will get to the root of who owns this phone number. When we now know that it is not your client, then the committee will now confirm that he is not the owner, or he is not the one that answered my call. And I said his father asked him to go and withdraw the petition. So that which means this is an arrangee before this committee. That's what we are trying to drive at. So 2366. Are you the owner of that phone number? You are not the owner. You are not the owner. Not that. That is not the owner. Do you have your phone here? Eh? So what?
With my lawyer.
It's with your lawyer.
Yes.
Where is the lawyer? You have the phone here?
Yes, actually, the phone number and the SIM and the phone, they have been with me right from the inception of this case because there have been a lot of, I brought an application before this court concerning threats. They've been threatening him.
Wait, sir. See, what this committee is interested to know is this.
Yes, it's with
this
me.
number.
The SIM.
No, this SIM, no. This phone number, does it belong to your client?
No.
Address on the letter is Clement Swagwat, Care Nakpat Dombong, flat 613, phase 4, Unity Road, Kuduru, Army Estate, Abuja. The chairman, Senate Committee on Ethics, Privilege and Public Petitions, National Assembly Complex, 3am Zone, Giaki, Abuja. Dear sir, the petition of Mr. Clement Swagwat against the brutal assault and violent attack by the Code of Conduct Tribunal Chairman, Danladi Umar. I, Clement Swagwat, the petitioner in this matter, hereby discontinue and or withdraw my petition wholly against Mr. Danladi Umar, the Honorable Chairman of the Code of Conduct Tribunal, CCT. Thank you, yours faithfully, Clement Swagwat, 08116 382366. That was the letter received by this committee. And immediately I learned of this particular letter, I called this number. And you answer in the affirmative that your father asked you to go and what? And withdraw the petition. And I ask you a further question. That is your lawyer who have been acting pro bono for you on this particular matter that has become a subject of discussion all over the world. Is he aware that you have withdrawn this petition? You said no. And I said, contact your lawyer and come back with a position paper to this committee. And a new date was slated for hearing on this matter. Since then, and I ordered the clerk of this committee to get in touch with your lawyer with a copy of this particular letter to confirm whether you are the one or not. Since then, you never responded in black and white that you are not the person who claimed to have written this letter. Well, today, the truth will come to pass. Unfortunately, the Code of Conduct Chairman again is not on seat today. But if you are representing him, I think the essence is to come and tell us what transpired for the Senate to receive this particular letter before us. So, sir, you are representing him. And where is the Chief Registrar of CCT? Where is he? Please come and have your seat. You need to tell us what surrounded the basis of this particular petition, this particular withdrawal from the committee, and what is the position now. You need to tell the whole world, so that members of the committee will be able to look at it, whether the action taken by Code of Conduct Tribunal or the Swagwat, who now denied that he's not the one who wrote this letter. Then who would have written this letter? The state don't want to go to the bottom of the matter. Who wrote this letter? If the man now is denying. So what transpired between your client and the petitioner? Tell the whole world to hear. Please, let somebody they should give a seat, sir. The man next to the, give.
The letter in question, first and foremost, with greatest respect,
Yeah, he said he's denied that he didn't, he said he was his father. Now he's denying that he's not the one.
First and foremost, we are not the maker of the documents. And we were not there when he made the documents. We cannot speak appropriately about the documents that our clients did not make. Since we don't have knowledge, or we didn't make the documents, the one who made the documents, who have denied it, possibly in the court of law, wherever, he would appropriately tell the court whether he made the document or not. As a matter of fact, distinguished chairman and the distinguished committee, we have filed a matter in the High Court in respect of this. And we have that process forwarded with a letter to your distinguished committee. Apart from that, we've also filed an originating summons accompanied with a motion notice at the Federal High Court challenging the powers of the committee to look into matters like this as is provided in the Constitution. So, this matter is already sub judice because it's before the courts.
Incidentally, this committee supervises Code of Conduct Tribunal by virtue of the standing order of the Senate. This committee supervises, oversees the activity of Code of Conduct Tribunal. In the first time, we have a right to summon the chairman of that tribunal to come and answer any cases before this committee. Apart from that, this committee is a special committee of the Senate. And any case before it, we have right to hear it. But if the case are going to court before coming here, it's sub judice. National Assembly is an independent arm of government. The function of the executive, we cannot perform the function of the executive. The executive cannot perform our own function. That is why, if a case goes to the judiciary arm of government, another independent arm of government, before that complaint is laid before the court of the people, we say it's sub judice. It has been taken care of. Let the court go and judge that case. Not when the case is before National Assembly. Before we now call you to come and respond. You now quickly run to court to go and stop National Assembly from hearing it. Even the Chief Justice will hear from this one that it's wrong. A case is before us already. We have had the respondent. We have had the petitioner. We now ask the respondent, come and tell us your own side. You use sickness. First, second time, third time, the fourth time now, you come with court summons that we can no longer hear the case. Okay? I'm not a lawyer, but I know the rules of the game. The question is that your man will still come to come and tell us. Even if we are going to drop the case for court to hear it later, we must hear his own side. There are different issues now. This boy says he's not the one that wrote, but I called him, he confessed to me that his father has to go and withdraw. Now, he's now telling the whole Nigeria that he has not withdrawn. And now you say you are coming with two, originating someone now to solve this committee from hearing this case. Even the president will hear about this one, though, where you use justice to stop the National Assembly from doing its own work. So, sir, I think you can. You are a lawyer. You are the chairman of the judiciary.
Well, a member of the Nigerian Bar. Very well, sir.
Thank you. Well, let me take us back. In the first instance, you didn't do well at all as an attorney standing in for a client. You stood before us here to tell us you were representing a client, to tell us why your client was not present in court. You said he had been sick. The chairman reminded you that there had been a series of meetings, and this had always been the reason why he didn't come. You insisted it was because truly he had been sick. And then we ask you whether his court had been sitting. He presides over a court, the Code of Conduct Tribunal. Rather than you to say, oh, yeah, because of the sickness, he had not been sitting, or he had been sitting. Because you yourself knew that if you answered that he had been sitting, that would be a contradiction to what you were saying. At that point, you found it convenient to say, oh, you wouldn't know, you couldn't really tell whether a court seat or a tribunal seat is public knowledge. And if you are representing somebody, that's a question you should be able to ask. You didn't come here. All the time they had been saying, his lordship was ill. Nobody brought any medical report to this place, or a letter from a doctor at least to show. And that's the honorable thing to do. Now, this is a Nigerian. A Nigerian. Forget about his status. We don't have two sets of laws. One for highly placed Nigerians, another one for average Nigerians. This represents an average Nigerian who also has rights under the law and who must also have access to justice. And that's what we are here for. And in any case, as a lawyer, you also know that the courts, up to the Supreme Court, have continued to hold that no arm of government can hold the other arm of government from doing its job. If this matter was already before the judiciary, was in a law court, the judicial arm of government, we would not even have entertained it at all. And his lordship came here and appeared. And this petitioner and his lawyers commenced this matter. When he was supposed to respond, he simply told us he was seeing the petition for the first time against even, attempt by the secretariat of this committee to let him know that he was probably sacked. But the committee still obliged him. He was to go and prepare his response. And then since that time, there had been all manners of drama. And then you have come here today now to say this matter is sub judice. No. The court will even have to decide whether in a situation like this, a matter can be said to be sub judice. He was not in court. Nobody was in court. This average Nigerian chose to come before this committee rather than go to court. His lordship surrendered himself to the jurisdiction of this committee by also appearing, knowing fully well that as a constitutional matter, this committee has oversight functions, has oversight authority over the Code of Conduct Tribunal. The way our law is written, no institution is an island unto itself. All the courts in this country are under the jurisdiction of a committee of the National Assembly. That's why we have the Senate Committee on Judiciary and Legal Matters, the House Committee on Judiciary and Legal Matters. Those committees oversight all the courts, including the Supreme Court. His is a tribunal and is oversighted by the Senate Committee on Ethics, Privileges, and Public Petitions. Same in the House of Reps. So this is like come here to tell us he's above the law of the land. He's not. Does he have a right to go to court? Yes. He has a right to go to court. But this is a matter that has not even taken, he has not even allowed it to take off because out of sheer respect for him. And now look at what has been happening in between, all manners of drama. This is a petitioner who purportedly had written to us to withdraw his petition. And they put a number there, a number which the chairman of the committee called. And somebody pretending to be the commissioner actually also answered. And this is the lawyer to the petitioner, a member of the bar like you, insisting that nothing like that ever happened. His client did not write. And he's here with his client. His client has corroborated what he said. The only option to the committee is to discountenance, that petition and go on with this matter as if it never even happened, because this is the petitioner before us. And now, on the other hand, you are saying this matter is just sub judice. This matter is not sub judice. This is an abuse of court process as far as we are concerned. You are trying to use the court to twist, this committee to, further twist this petitioner, this young man who is seeking for justice, and you want to stall this matter. You could have served your court processes on the National Assembly. That would not have stopped us from sitting, because the National Assembly also has a legal department that will go and represent the committee in court, simply to tell the court that this matter could not be said to be sub judice, because this is how it started, and these are the holdings of, the Supreme Court on this in this regard. We cannot be stopped from doing our job. We didn't come to court to take over a case that they were already adjudicating on. So, trying to use the court to ambush justice in this matter is extremely and thoroughly unfortunate.